In 1954, Linda Brown and her sister from Topeka, Kansas took a dangerous route to school every day. Her parents thought this was unfair, seeing that there was an all-white school closer to their home. According to the editors of LandmarkCases.org, the parents took their children to be enrolled in the all-white school the following year. However, they were denied acceptance and were forced to go to one of the 4 African-American schools in the city. Her family believed that it violated the 14th Amendment, and they brought their case to court. They believed that you cannot be separate but equal. This was a major issue at the time, and there were 5 more similar cases in Kansas, Delaware, D.C., South Carolina, and Virginia. In the case Bula v. Gerber and Belton v. Gerber, black students in Claymont, Delaware were not allowed to go to the all-white school in their town with 400 students. Instead, they were bused 90 minutes downtown to a school with 1,300 students, according to the creators of CivilRights.org. During the time of the case, Bowling v. Sharp in D.C., the state stopped the maintenance of the black schools. The editors of BreckBrown.com stated there was a population increase and nothing was done to make new schools or improve the old. Black parents requested that their children attended the all-white school, and they were denied, even though the school had more than enough availability. The authors of CivilRights.org explained how Harry and Eliza Briggs and 21 other families armed together in an attempt to find a school bus for their children. The bus was in need of a lot of maintenance, so they asked the superintendent, Elliott, who refused and said that the black people didn't pay enough money in taxes in order to receive a bus. The white kids of Clarendon County were given 33 buses, and black children had to walk up to 18 miles to get to school. In the case Davis versus County School Board of Prince Edward County, Barbara Rose Johns protested with 450 people for 2 weeks because R.B. Milton High School, an all-black school, suffered from terrible conditions due to underfunding, says NPS.gov. The school did not have basic necessities and amenities because of overcrowding. Certain students had to take classes in an immobilized, beat-up school bus parked outside the main building. Requests for funding were denied by the all-white school board. The local level courts all deemed that the segregated schools were substantially equal to one another because the facilities were similar and did not have an effect on the students' learning, which was a precedent set up in Plessy versus Ferguson. However, the facilities were not equal. The Supreme Court granted the plaintiffs' petition for writ of certiorari on October 8, 1952. Thurgood Marshall and the NAACP Legal Defense and Education Fund combined previous cases together and brought them in front of the Supreme Court. It was placed at number 1 on the Supreme Court's docket. Brown v. Board was brought to the Supreme Court because it was a major controversial issue at the time and is now a landmark case. A landmark case is a court case that is studied because it has historical and legal significance. The most significant cases are those that have had a lasting effect on the application of certain law, often concerning your individual rights and liberties. Segregation was a major issue at this time and took place in all aspects of life: social outings, facilities, neighborhood, and schools. Allowing there to no longer be segregation in schools was a major milestone and set the ball rolling for civil rights acts. The editors of LandmarkCases.org stated that Brown fought for the Equal Protection Clause, which states that no state should deny a person equal protection of the laws. According to the 14th Amendment, you can't impose distinctions based upon race. That reduces the benefit of public education. When the 14th Amendment was created, education was controlled by private organizations. In addition, there was testing done that proves negative psychological effects to black children. United States Attorney General J. Lee Rankin presented an amicus curiae brief on the behalf of the appellants. He also supported the desegregation of the public schools. They provided evidence from the previous case, Sweat v. Painter, where Herman Sweat was rejected from a University of Texas law school and pleaded the 14th, that its facilities and the Texas University for Negroes was not equal, and won. The Board of Education rebutted that the 14th only states that people need to be treated equally but not the same. They only have to give people what they need so that they are comfortable while learning. Their support was that whites are more comfortable learning with whites and the same for colored. Also, no psychological studies were taken on the children in Topeka. No black students have committed self-harm. At LandmarkCase.org, it states that in the past case on Plessy versus Ferguson, the court ruled that separate but similar facilities for whites and blacks on trains is legal. Education is a federal jurisdiction, and the education rule is up to state and local legislators. Housing and education have been interdependent because local government will be placed under a lot of pressure to change neighborhoods.
Also, local area conditions must be taken into consideration, and it could be a hassle for the government.
On December 12, 1953, the justices went into conference after the conclusion of all the oral arguments in order to decide the outcome. The court opinion decided by Chief Justice Errol Warren was that the segregation of public schools was a violation of the Third Amendment and unconstitutional. The role of public opinion in this case ruling was non-existent. It was such a controversial issue, one side could not sway the court. Most whites in the South supported segregation, while some whites in the North and African Americans were anti-segregation. The ruling was unanimous. However, in a previous case used for reference, Plessy v. Ferguson, there was not a majority opinion, but a dissenting opinion because Justice Harlan disagreed with his other colleague.
Education is the most important function of state governments. The ruling in Brown v. Board has had a major impact on both government and society. As Valerie Strauss said in the Washington Post, the mission of ending segregation in public schools was a success. Today, in school, the focus is no longer on separate but equal policies or the benefits of integration, but only on the achievement of the students.